Oops.
Excuse me.
Thanks, Ann. All right, we are back from lunch. It's 1:30. Working agenda, this is still July 11th. Working agenda, Corey Swanson, County Attorney, pending county issues. Come on up, Corey.
Kicking off our inaugural working agenda meeting apparently. Yes.
Absolutely.
I'll try not to, mostly I'm giving you updates, a few questions, but mostly just start with some updates for you. First of all, I believe I sent an email, I did send an email regarding Bill Fleiner. We received a letter from Department of Justice, Montana, or U.S. Department of Justice, that Bill Fleiner has been indicted in federal court for various criminal acts. I have not actually gotten his charging document. When I get that, I'll give it to you. But the county is listed as a victim, and so we'll, as a victim by federal law, we'll get updates from time to time on the case, and I'll provide those to commissioners when I get those.
There was something in the Helmet papers, and then they had it on TV the other night too. I don't know if you saw that or not. That was the same interview that they did with him 3 years ago.
Yeah, and I had heard that there was some press inquiries regarding dates he worked here and things like that, and I obviously didn't know that, so I don't even recall who got. Some reporter called somebody and they asked me, and I said, well, if it's public information about when you worked here, I'm sure give it out. Beyond that, I didn't know anything. So when I get those documents, I'll provide those to you.
Okay.
On the Galzagori subdivision, if you're all aware that we've gotten a request for records by the Bloomquist Law Firm in Helena. I have gotten so far a binder from Commissioner Robert. I'm meeting with Julie sometime this week to see if there's any sanitation documents associated that she may have. I haven't met yet with Nicole Brown. I'll do that. And then we are going to need the videos of any county commission meetings where it was discussed. So if whoever's in control of those, just burn those on a disk, that would be helpful. And I'm guessing there were probably the one with the preliminary approval, which would have been in, when was that, February?
I gave you 5 different agendas, so I would think those would be the ones.
Okay.
Preliminary was April, if I'm not mistaken.
Okay, April.
And
I haven't gone through your binder yet, sorry. So
Oh, okay, well, you'll see all that then. And I don't want mine to be the only one from the commission. It's not from the commission, it's just from me. So I do think you need to receive theirs separately.
Okay, any documents that you have, I need copies of them. Keep our originals. And that includes any correspondence with Mr. Well, really anybody, the surveyor. Seems like we didn't really have a lot of correspondence with the actual owner developer. It was mostly through Shelburne Survey, correct?
Mm-hmm.
But then anything with Mr. Hahn as well. So I've got a few emails, but not many. I cut a couple.
Now, when I was reading through that, it made it sound like Galzagori, they don't own these certain tracks, but maybe I'm reading it wrong. It makes it sound like they own these tracks 2, track 3 that they're requesting this information on.
What I believe it said is they have a property interest in them.
Okay.
The property, I mean, I don't know, other than knowing that there's a ditch easement, and that's a property interest through those
Yeah,
tracks.
that's right.
I don't know what other property interest.
Okay.
I don't think that Galzer's ever owned that themselves.
No, that was owned by Lee Reynolds, who sold it to the Galzagori. Or it went, I believe after Lee died, I think it went to his sister. And the Galzagoris have not owned that property. I think they have, like you say, the ditch easement through there. But
Was that part of the Cook estate?
If it was a long time ago, frankly.
Well, it would have been, or.
I'd have to go back and check, I don't recall,
Yeah,
but it might be.
doesn't matter, but somebody said once that was part of
Okay.
Herbie
And
Cook.
my goal is to, by the end of next week, be able to have everything compiled. Because as you know, I'm taking off and I'd like to get that to them.
One thing on that a citizen asked me to make sure is in the minutes is who is that subdivision? The rumor is all over town that it's a Kavanaugh subdivision. It's not, it's Graves Job, and so I just wanted to put that in the minutes.
It's what?
Or Graves Job was the developer,
But not the owner of the property.
correct. And O'Brays were the owners of the property, that should probably be there as well. But there's a fear that it's Steve Kavanaugh subdivision, and that's who sued the county. We won a couple of years ago, but there's some ill feelings, so this is just in response to a citizen.
Okay.
Very good.
Does Shrove owns this ground around it?
No.
No, he does not.
Well, anyway, if I could just get your documents, and then I'll, like I said, I'll meet with Julie this week, I need to meet with Nicole hopefully this week, and we can compile them all together for them. We have another, which I have not yet even compiled everything and read it, but there's been correspondence between Tara Depew and Nicole over another pending subdivision issue with the road that I need to look at. So that's as far as I've gotten on it. And I understand there's a tax deed issue from Doug that Tara Depew has also been corresponding with Doug on, and she's been copying me. So I haven't done anything other than realize that there's a couple issues out there pending. So hopefully I can clear a little bit of my stuff and go through those issues and give you a report next Monday. As you know, I'm going to be gone for a little while for National Guard, and I've arranged for Luke Berger, who is a deputy county attorney in Lewis and Clark County, to provide coverage for the county on any mental health commitment cases that would come up. He's routinely done that in cooperation with me. And then Mary Kokenauer from the Attorney General's office to provide coverage for any emergency issues. Those are really all criminal, but if there's any civil issues, can ask the MACO to provide that coverage. So what we would need to do, what I would ask the county to do, or the commissioners to do, and I'm drafting them today, so I can get them to you fairly soon, is do a resolution for each of those lawyers, Luke Berger and Mary Kokenauer, authorizing them as special deputy county attorneys for Broward County while I'm gone. That allows them to, if they file anything in court, they can do that.
Are you gonna draw them up for,
We'll
you gonna draw up
them
the
up.
resolution?
Yes,
Okay.
we'll draw them up.
We need to advertise for 2 weeks for any resolution, so if they have to be in that form, we should have them 2 weeks before, and we don't need to do it in a closed door.
Right.
We would do that in open.
Right.
Okay. Just last time we did it in closed door, in reviewing that, we
We
probably
did?
shouldn't have.
Hmm. Yeah, there's no reason for that.
Yeah.
Okay.
So you have Luke Berger for the mental health, Mary for criminal, and then Mako for civil.
And I haven't yet talked to Brian Hopkins, but I intend to. And for Luke and Mary, it doesn't need to specify exactly what they are. It's just they have arranged that they'll provide that coverage, and so just the special deputy county attorney for Butler County is all I need from me.
And you leave next Thursday?
Don't know, another week,
Oh, okay.
maybe.
How long are you gonna be
Don't
gone?
even know. I gotta figure that out.
You told me the 25th,
No, 21st.
21st, and today's the 11th, so it's 10 days from today. So can we do something other than a resolution, maybe another term?
I don't know.
Do you have
I don't
just
know
an
that it has to be a
acknowledgement
resolution.
type thing?
It's just a motion. I don't know that it has to be at all.
Okay, so if we could just not call it a resolution to keep it clear, then we don't need to follow that 2 weeks, because I hate to, 2 weeks would be the 25th, you'd only have gone 2 days, I suppose.
If
So,
one
I
comes
guess
up
it's your
before
call.
that, you could do it on an emergency basis. So-
Okay. Yeah, we'd have to have it today for the newspaper, for the legal ad,
Okay.
okay?
And then you'll be back on,
12th, I'll be back in on the 15th.
gotcha. Thank you.
Looking at your Wednesday agenda, I don't have any documents on the public health department and nursing home support policy or the county budget goal setting. So if there's anything you want me to look at for those, I don't have them, so Is
No,
there
I-
anything-
No, I would have certainly, sent you an email, because those are new things, they're just discussion. We need to start a discussion on public health, because we're understaffed. And, we have some budget questions and task orders we have to discuss. And then the nursing home support policy, that is from the 10 o'clock meeting. Because of the working meeting, you can't really make a decision. I just put it down there for in case somebody wanted to make a decision. That's at the request of Jenny and Kyle to discuss the nursing home with the county.
Do you know what they're proposing though? Or what they can use? Do we have anything in advance of that, or just kind of whatever they walk in and say is what we're doing? I mean, now
Oh,
that
no,
we're doing
no.
what we're
We'd
discussing?
never do that.
No, what we're
It's a
discussing?
discussion.
Okay.
It's a, well, yeah, and that's why it starts as a working meeting, so we can just have a discussion.
Okay.
But they want to have the ability to talk to all three of us at the same time, so it has to be a public meeting.
Okay.
So that's, and that budget goal setting really is commissioners' work, so that'll be just us reviewing what we already know about the budget, what we think about the budget, and the information from the
It-
morning.
From time to time, well, today's an example. Yeah, for example, I called in and said, is this contract valid? So it'd be best if I know in advance what this issue is, if I'm gonna be asked a question on legal advice on a particular issue.
Sure.
So I'll assume that I don't need to be involved in Wednesday.
That's exactly correct, and that's why I said I would have let you know. I didn't know that was gonna come up today on the building project. We had talked about it, honestly, I think some months ago, and I thought it was settled. So, yeah, if there's anything like that, I'll continue to let you know ahead of time.
Now, this
And
Wednesday
I would
meeting, we're
ask the
starting at
same
9.
fellows.
Correct. 9 o'clock.
Okay. Did you appoint someone for the city-county liaison committee, or is that next week?
No, we did that last Monday and I was on that.
Or did you appoint a county resident also?
Oh, no, we have not, well, we haven't received the,
I honestly don't know that we've received any interest.
interest,
I haven't
yeah.
heard anything back and forgot about it until just now. We'll have to follow up with Nicole, and maybe we'll have to do that Wednesday, because I don't
Drive
have
somebody.
anything. She's in.
Congratulations, you're on this committee. Okay, my last issue is I've been talking to Debbie, talked to her 3 times now, and I'm not at all clear on our process on, I'm aware there's a number of outstanding warrants for reimbursement to Commissioner Slivka for mileage and phone. And I'm not clear where they are in the process. I know that they are prior budget years, and having reviewed it at length, certainly the mileage one is by statute needs to be paid. The phone one, it's not clear to me on what our current phone policy is or what it was at the time they were submitted. But, so I've asked Debbie, I need to see all these claims, and I haven't gotten them from her yet. She's said she's struggling through some things with the auditor getting approval to pay for something from the previous fiscal year. And my sense of it is she's needing clarity from the commissioners. And so I said, well, I'm gonna bring this up to the commissioners and say, what are you guys doing on this? And she said, yes, please do, that will help me. So I'm bringing it up to the commissioners and saying, what are you doing about this? These are claims that are very old, very past due, need to be paid, and no one knows where they are. I don't think you even looked at them today, did you? So,
I have a lot of them. We can discuss this in detail.
okay.
Yeah.
The dates are on all of them.
Are you ready now?
Sure.
Is that the last thing?
That is the last thing, other than, is there I guess in general, the warrants policy in general, there's, from time to time, there seem to be ones that get held up, and I don't understand why. There's some odd ones in my office maybe isn't a good example, but occasionally they go through, and then I get these past due notices from Alexis, my legal research thing that I pay for, and they're like 2 months overdue, and I'm going, why are these overdue? And occasionally there's like this bottleneck in the system, and things get stopped, and they don't make it to you 3 commissioners to decide, and I don't know why that is. It could be just an oversight, but I'm concerned that if my experience is common, that there may be a number of them across the county that we're losing visibility on them somewhere between when the department head signs it and the commissioners receive it. So I'm not complaining about mine currently, because I think it's now current. It's an example that I noticed, and I'm concerned that maybe it's more widespread just me. So,
I know there were some issues like a year ago, that those, I know that, you know, your department and accounting go back through that. I won't say anything more. I thought it was worked out. But as far as anything else, I haven't heard anything like that. I don't know if you guys have. We go through the claims. I just sign them every Monday. And of course, everyone knows where they're at to look through them. The reason they're not coming up here anymore to any commission meeting is because there's either HIPAA violations in some of those, and we don't have anyone who's pulling those out. We don't have a process for pulling some out. And then we had about 20 for election judges that had a W-4 connected with them, the social security numbers. Just not a good thing for public domain. So the policy was changed a year and a half ago to keep the claims downstairs in the accounting office. Each commissioner either looks at them there, takes them to our office, brings them back, and pulls out any that there's issues or questions on, talks to Michelle or Tammy at the time, and it goes from there. So without a receipt is something that would hold up a claim. There's not a receipt, something like that. If it's just boilerplate, then they're approved and they're paid usually within a week.
There never was
So
a
that's the
policy set up.
process.
All the time when Elaine was still here, the claims were, went through and they were brought into the meeting.
Okay, that's not true, but before we get into that, I did want to ask you one other question, just because I think it's short, and it's on the email that we all received from MACO on Marcy's Law. They are looking for input from commissioners, county attorneys, and justice of the peace. The issue from my perspective, and I would think from all three of our perspective, is the part, could I get that back one more time? On the ballot language itself, it says fiscal impacts are expected for the office of the public defender, yada, yada, and local governments from passage of CI 116. But those costs could not be accurately determined at this time. So we're looking at a financial hit on counties, which becomes our responsibility as well as yours and the Justice of the Peace, I would think, and I'm not sure whatever other departments. So I don't know anything of the legal side of that, but they were asking for a response last Friday, at the latest today. Can we have a response jointly from Broadwater County team, from say the leadership team on that? MACO's been asked to be kind of the head educator, just so that citizens have both sides on this.
And I wasn't quite sure what kind of costs would be incurred. All you're doing is sort of like what they do now with notification of victims. I mean, I don't know what else. It's not like you're hiring personnel to fall in line with some of this stuff. I mean, I think it's a lot of it's covered already by, the sheriff's office policy, the detention policy, even the form you give out to victims from the victim advocates. So I would agree. If there's a price tag attached to it, we need to have something. But I just couldn't envision being what kind of price tag you're talking about when a lot of it's already covered in, or should be covered in policies.
Well, first thing I would say is in terms of our response, I don't think that we should have an official county position on this, because that will be using public time and resources to apply.
That's not what they're asking for.
No, I
Then-
understand. I
Okay,
understand
good,
that.
good. I just want to make sure we're all on the same table.
I'm prefacing that.
Okay,
So, anybody can go forward and say, good idea, bad idea, but just can't do it on public time or public resources. What they are asking is, do you see any impacts from this constitutional initiative, fiscally, local government, whatever? So what I would say is a couple things. Number one, if you look at these, compared to, we only have half the pages here. I think it maybe was front and back, and I'm not sure if it is, but we're missing part of it. But anyway, oh no, we are.
right.
In terms of impacts that I see, we are doing 90% of this already through Brooke Dolan, our victim witness advocate. Give you an example. The right to confer with the prosecuting I confer with every victim on a case before, when we start the case, give an expectation, if we're gonna do a plea agreement, before we do a plea agreement. There is that rare exception when I don't, because I can't reach the victim. Sometimes the victim is just plain not cooperative, sometimes they moved away. So there is that rare exception when I don't personally talk to the victim, but it's usually myself or Brooke. We do unless we just can't get the person. And I think that's considered a best practice. There are some legal requirements as far as involving victims, and a lot of it is also just kind of the profession's best practices that involve. Interesting one, proceedings from unreasonable delay into a prompt and final conclusion of the case and any related post-judgment proceedings. So the way it works now, the victim doesn't have a right or a voice when it comes to scheduling. And I had a case last year, a very difficult case, that the defense kept extending and continuing. And I was arguing, after I agreed to the first one, after that I was arguing against the extension, saying the victim should have a right here for timing and for closure. And the judge said, yeah, I understand that, but the defendant has a constitutional right to prepare their defense and they're not ready. So that one, this one would strengthen that, but it would strengthen it only to the point that you aren't harming the defendant's ability to prepare for trial. There's two that I think are, to receive reasonable, accurate, timely notice of proceedings. Again, we do that. We do not do every single thing, like initial appearance, arraignment, omnibus, there's all these things. But if there's certainly for any change of plea, any pretrial hearing, or certainly sentencing, we always tell victims and they're invited to come, and a lot of times they do come and speak to the court. So that would be more notice than we currently do, but it wouldn't be crazy amount more. The concern is this: in criminal law, the schedule is very fluid, and there are many times when something is set on the docket on a Friday, and on Thursday, the lawyers talk to each other and realize they need something's not quite ready, and so they agree, we're gonna bump it to the next week, and you tell the defendant and you're good. Well, if you either told the victim and they've traveled for it, or you miss one of the victims and they show up here and they're mad. That actually happened to me on Friday. Friday we had continued something, we screwed up and didn't tell the victim. Whole family was here and they're mad. And so I'm out there apologizing to the hotel, and it's my fault, as it was. But that does happen with everybody. You're going to lose some. Stuff's going to fall through the cracks. What this would do is, I think, increase kind of the risk of some of those oversights and falling through the cracks, and it would also it would increase the number of times when victims are here, and they're just, in terms of the criminal law process, there's simply a lot of fluidity, which drives me a little bit crazy, but there's times when things just get bumped a week or 2 weeks, and then.
So, going along with that, are the victims compensated for their travel, or do they get per diem? Is that a cost that they might be adding to that?
They're not compensated for travel for just to come observe something. If I call them as a witness, then yeah, there is a witness fee for travel.
But if they just want to come to the initial or.
Right.
Okay.
Yeah.
Since this will be part of the Constitution, if it passes, is there, like Nick was asking, a remedy for the victim, or a fine, or a judgment against the county or county attorney?
And that's the big concern. That's my number one concern with this. Well, there's two. There's another one, the big one I'm going to, but I've said to the folks who are doing this, hey, we live in a plaintiff lawyer state, and I can see where either I do a decision on a case that the victim doesn't like, which was probably going to happen at some point. I'll sit down and talk to them and say, I understand, I'm just going to do this. And really where it more often happens is where I'm harder on the defendant than the victim wants me to be, because the victim's a family member. And they're saying, just drop it and let it go, and we want to move on with our life. And I'm saying, no, we're prosecuting it. So in that case, you are going to have possibly a conflict. I'm worried about lawsuits against against the county, against me, against Brooke, against whomever, the judge, saying you violated our rights as victims. But then the last one, and this is the one, if this was cut out and everything else was there, I would not be worried about it. Well, I will mention one minor issue. The victim is a very, very broad definition. It includes the person who's actually the victim of the crime, but it includes family members, out to grandparents, and anyone who's in a close family-like relationship with them. Well, that's really, really broad. I mean, that could be, for some people, that could be 5 people, or it could be 20 people. And so, if you're saying they all have a right to whatever in this proceeding, well, you're not gonna have agreement among victims. You know, you can only imagine, we have cases now where the two halves of the victim family hate each other, you know? And so you're trying to figure out how to balance what they want. You just have to say, I've heard you, and here's what I think is the right thing to do, I do it. So that in itself is an issue. Here's the one that's, in my view, going to end up at the Montana Supreme Court, and it's gonna be a big fight. And it is that the victim has the right to privacy, which is fine, but this includes the right to refuse an interview, deposition, or discovery request, and set conditions on the conduct of an interview, of any interaction which the victim consents to. And the issue with that is the victims are always going to be material witness in a trial. Without the victim, there wouldn't be a case, right? You need 2 necessary parties, the defendant and the victim. So they have to be part of our trial prep, and the defendant, because he has a constitutional right to prepare a defense, has to be able to interview them and pre-trial. And lawyers who don't do that are not doing their job. This is saying victims can refuse that. So now you do have a collision course between the defendant's right to prepare a defense and the victim's right to privacy, and saying, I don't want to provide anything like that. Where it gets sticky is, which happens regularly, is, and I have like 3 cases right now where the victim, usually it's a domestic violence case, later decides they do not want to cooperate with law enforcement. They don't want to talk to us, they don't want to be interviewed, they don't want to give up their phone, whatever it may be. They're the victim and they're the key witness. And so if they're now saying, I don't want to cooperate, then you're going to see a whole lot of domestic violence cases or other various cases like that where you just can't go forward. And so you're going to see a lot of these drop, and you're going to see a lot of cases. What we'll do, I'll tell you what we'll do, is we'll ensure that you do a recorded interview with the victim as soon as it happens, and then later when they say, I don't want to give a statement, well, too bad. And then you go to trial and they're on the stand saying, no, that never happened, and you're playing back their recorded interview saying, well, this is what you said the night that you came to hospital all bloody. So I can see where that issue of the victim not wanting to participate is really sticky. Here's where it gets really crazy, is the victim is now defined as family members, grandparents, even anybody who's in a close relationship with them. Well, on half of our cases, they're the other witnesses. You know what I mean? And so now you've got 3 or 4 witnesses that are all family members and saying, no, we don't want to cooperate. It's just that one provision alone is not going to work. If the rest of it, if it was without that, the rest of it we can work out.
Sure.
But that one, I see this as for sure going to be challenged to the Supreme Court. But because it's a constitutional initiative, they can't. It's very hard for them to say that doesn't apply. So it has to be balanced. That's going to be interesting. For other counties, I would say that you're likely to see more of a fiscal increase, both for example, Marr County. Marr County doesn't have a victim witness advocate at all. So they would have to do much more than they're doing now. For big counties, with a caseload that's 10 times mine, they're going to have a big impact because they're going to have to do a lot more outreach than they do. We have a part-time victim witness advocate, but she's basically doing extra work all the time on that. So I don't see that being an issue for us because we already do 90% of this.
She gets a lot of grants, correct?
She gets grants. We will probably ask for a grant increase from the board of directors. but we would be in line for everybody else we asked for.
Sure.
I do see a state impact. The Department of Corrections is gonna have to change some of the things they do. So that the state, there will be a state fiscal impact.
Well, and I know our, just because I helped with the policy in our detention center, we already have a lot of those in place already. So I think we're ahead of the 8 ball in some of this,
Yeah.
with notification and things of that nature.
Notification, restitution,
Yeah.
all those things. Yep. So I have not taken a position on it, we went through this in detail a couple weeks ago with some other county attorneys, we analyzed it. I do see that one issue being a big collision, of course, with the defendant's rights. I expect this is gonna pass, I mean, no one's gonna vote against victims' rights, so.
What they're asking for, and this came up at the Mako board meeting last month, 2 weeks ago, is they've been asked to write
The opposition statement.
Exactly. So that's why they're asking for some of this, not to take a side, but just to educate
Right.
voters. Will you be sharing with them your thoughts per this email? Do you want one of us to put together an email with your thoughts?
I could call Harold, I guess. I mean, I'm not by any means the only holder of this information. I mean, we had every county attorney in the state, well, nearly ours, who couldn't make it. We had almost all the prosecutors in the state were there. We went at our conference, and the guy who was advocating this put on it was at least 2 hour presentation. He had quite a hostile crowd at the end of it because we were asking all these questions and he wasn't really prepared to answer them. So, I'm not even the originator of most of these objections, so I'll call him, but I guarantee he has all this information
Okay,
that I just shared.
okay.
And particularly because we have a liaison from the County Attorneys Association to Mako.
True.
I think it's either Leo Gallagher, I think it's Leo Gallagher. And he wasn't there, but all of his deputies were there.
Okay. All right, I just didn't want to lose an opportunity to make sure that a point,
Yeah,
at least some more facts were shared.
Yeah, it is a concern. I mean, for the most part, it's a well-meaning, good thing that needs to be done. I don't think a constitutional amendment itself should be 2 pages long. I think it should be short. And then secondly, that one in particular, the definition of victim, I think are not, I don't know, they're.
I think they're shooting themselves in the foot reading, because that was a very lengthy explanation for something that could be very short. I think they're opening the door to shooting themselves, not getting the victims the quality of care that I think that this is trying to gain. I think they're opening themselves up for a lot of drop cases or plea bargains or whatever, because it's gonna tie the hands of the people investigating and prosecuting.
When I came in, I had already spent some time on training on that, on victims' rights, and so we came in, and that was something that we set as one of our #1 things to do on day one, and have done a good job of it. But yeah, even despite those efforts, I had 2 or 3 where I didn't notify somebody, dropped the ball, whatever, and had to suffer through that. So, and that's been with pretty heavy emphasis on that. So I'm sure others are suffering or will experience some impacts from it. Okay.
So the main thing I could see cost-wise would be, because more will be required, will be more for our victim advocate, price cost-wise.
Yeah, maybe some postage increase in terms of what we mail out, because some people are email people, some are not, some are mail people.
Sure.
So, it is hard to get full contact information. When you're at a crime scene, you've got 1 or 2 cops there, and you've got 5 or 6 people coming and going, and you're trying to grab witness names and phone numbers. It's easy to walk out of there with half a name or half of a phone number. And so yeah.
sure.
Okay.
All right, thank you.
So, I guess, kind of, the last thing Glenn finished is the reimbursements on Commissioner Slivka's mileage and phone. Where,
Yeah, there's a
what's the
bigger
status?
story to that than I think what your understanding is, for whatever reason. But, just to the phone, first off. This is just in my opinion, if we are going to change, practice and precedent, I think we should have a policy. And you guys can outvote me on that, that's fine, but I'm gonna present it. This is vastly changed from the previous one. Basically what it says, it's not a reimbursement because we have several people whose total bills come in less than $20 a month. So if we call it a reimbursement, how do you reimburse somebody for something they haven't paid? So, it's a payment instead of a reimbursement, that's the one big change, again, from accounting. The other thing is, following the same process, it's up to a department head or the commissioners to approve. There is an out clause for us. Nobody needs to provide anything other than their bill, I mean, for a receipt. You don't have to show your calls. But we do need to make sure that any employee or elected official is aware that they may have to give up their phone if there's a discovery or FOIA. And then the last one is instead of following the precedent and practice set by a previous commission to me, well, to all four of us, Ann was here at the time, although I don't know if you were taking minutes, but the previous commission wanted commissioners' phone logs, calls in and out, to be readily available to the public. So I propose a compromise. If Commissioner Slivka doesn't want to do that, then we just have it so that a citizen doesn't have to go through the official FOIA process to get that information if they want it. They just need to write a simple letter, and within 30 days that will be given to them. They're already on record for Commissioner Corthal's and me. And that would apply to any new commissioner that wanted to follow the same thing. They have 30 days to comply with a citizen, and it says just your calls on county business, so you could redact personal calls without an issue. And it just sets it at what we're paying right now, $20 a month for any phone. Smartphone, dumb phone, doesn't matter.
I think it's a good compromise from where we started at 10 and, was it 10 and 12 or 10 and 15?
10 and 20,
10 and 20?
yeah. And,
I think this is a huge step forward.
so if.
I think a cell phone policy is needed. I mean, obviously this is gonna be an ongoing issue, and it's not just with this commission, it could be a lot of different departments. I went through the claims, last Monday, and the road department turned in a bunch of claims for their, phone, and it was just a claim, it didn't have the phone bill attached to it or anything like that, so I mean, this is just not because of this. I think we need a
Right.
policy to better protect the county. And that's what policy and procedures does, is protect the county.
I used to be uncomfortable with paying the justice of the peace because there wasn't any policy and it was practice. I just accepted it. I think we all did. And this has grown into a can of worms. Like you say, it's more than just one individual now. It's a couple of different departments. So I feel better myself with the policy. I will tell you, several citizens who were here the last time we discussed this said you shouldn't have even the option. This does save money. So I can see both sides of that, but I just don't think we should move ahead without a policy.
I'm not against having a policy, but this doesn't refer back to my claims.
Well, I think that's part B and C that we still need to discuss. And we certainly can. But I
The
just
president's
don't
been there.
feel we can.
Just like I said, a good example, here's Bill Fleiner now, out there by the grand jury. He had a cell phone for, well, I don't know how, he probably had it even up to the time he would finally resign. And I brought him up before, that one particular month. And I had it in my, when I presented all this stuff, I think he had 300 calls and all these text messages and everything. He should have, supposed to have a phone. Once he was put on administrative leave, he should never had that. That's just one example. And I got all them others too that I presented before. I don't have that stuff here with me because it's, should be cut and dried. So that's the way I feel on it. And if not, we'll carry on. And I'm not against the policy. Now, if we're gonna have one, that's okay, that's different. But it doesn't refer back to mine.
I think it's a step forward. I've worked for a lot of different agencies, including a cell phone company that had a cell phone policy. You know, I think we missed an opportunity. I mean, we just did policy and procedures in March. Is that when we voted that in?
No, you were on board, because we couldn't
Yeah.
get it done without you, and you started in April.
Okay,
So I
so
think it's
April.
mid-April maybe?
Yeah, so April. I think, you know, that's why policy and procedure is such a growing beast. But it needs to be done. I mean, every agency, with the exception of Broward County, has a cell phone policy. We even put one into the 911 dispatch policy on usage and things like that. So, I mean, we have it, it's just,
And we do have one for use in the personnel
Yeah.
policies, but nothing for
Exactly.
excuse me, payment, not reimbursement.
See, the road crew, they just come in, they wanted to go back 3 years on it. And this was sometime early in the spring. And I agreed for the $20 a month. So, and I said, I let it go retroactive back to the first year. But they wanted to go back, and I'm pretty sure it was at least 3 years that time.
Could I have a couple of suggested edits on the
I
last
welcome
paragraph.
edits 100% of the time, so thank you.
So in the last paragraph, the Freedom of Information Act doesn't really apply because that's a federal act.
Okay,
It's Montana's open records requirement, so,
on the second page.
yeah. So it should probably say, subject to Montana statutory and constitutional open records requests. I probably should email these, or I can hand this off to somebody who wrote it.
okay,
Right after that, I would put a sentence, any disclosure must not violate protection of confidential criminal justice information as provided in Montana law. Because I can see where a deputy is using their phone, getting reimbursed, and they're calling a witness or a victim in part of their investigation. And, you know, we don't want that to be disclosed until we've charged a case. So up until the point that it's charged, that information's confidential, so that'd be easy to make a fix there.
I didn't write down your words, but I would love to take your
Okay,
handwritten edits,
and then.
if they're legible.
And then, so the very last part of that paragraph, within 30 days without a formal, instead of FOIA, it should just say open records request.
Okay,
And then, the big one is this whole turning it into the county attorney thing, that's. So, I'm assuming there's a reason why we turned into the county attorney?
well, and what it says, maybe it's not clear, and maybe that needs some wordsmithing too, but if there was a discovery, so a lawsuit, a, trial, or that's why I would go to the county attorney. But if it's just a request for records that isn't following a legal issue, then it could just be through their department head and then through the commission and then to them.
Okay.
So we can change that wording too.
Yeah, I would figure out how to, I mean, if it's a discovery or lawsuit one, obviously it's gonna, have to go through me. If it's just anybody that wants someone's call log, I don't know, if that needs to go to me or not.
I would think it'd be easier not to, again, in streamlining what you do. So if we could wordsmith that.
Maybe just say, she'll turn in their phone in coordination with the county. How's that? So for some, I'll have to be involved, and for others, they'll just tell me what it is, and I'll say, okay, just do this. Make sense?
Yeah, yeah.
Okay, that's those are my only suggestions.
So
Okay.
do we need to make a motion and pass this then?
I would say you probably need to put it on
Probably should put it on an
Agenda.
agenda so we can let department heads know.
So we wanna do this Monday then?
Okay, what's taking place on my claim?
so
So
that's
that's the next
the next
part.
question.
Yeah, okay, so this will go on the agenda on Monday then.
To adopt the cell phone payment?
Yes, yes, okay.
Now, quick question on the payment. Will that be in their regular paycheck each month? Is it $10 a month, $20 at the end of the month?
I talked to Debbie about that as well, again, in the interest of clarifying for accounting. They do not want to put it in the paycheck, because then it's subject to FICA and all those other things. It's easier for them to just cut a check, it's a
Okay.
claim, goes through us, gets approved, and
Okay.
she's fine with monthly, quarterly, half year, whatever.
All right.
So, if this becomes something where it's onerous, you know, we're doing 100 claims a week, a month,
Yeah.
then we're gonna have to readdress this.
That's why the road crew always
So-
been theirs every 6 months.
Okay, now to Franklin's for his phones. And this is a budget here for this.
Before we do
Sure.
that, I would
Yeah.
recommend though that you do scrutinize who actually needs a cell phone for their work, because not every county employee needs one. That's just all there is to it. I mean, I would just recommend you scrutinize that and not just automatically do it.
Well, and that's in here. Employees determined to need a cell phone for business purposes, underlined, may choose, and then it says later, there's a process that they go to their department head, who comes to the county commission, who then approves it.
Right.
And we can pull this back at any time if there's no money in the budget, or if there's another reason for not doing it. Leaves it totally open to
Yeah.
management,
I'm
which
just
would be
like-
the department head or
And
commission.
I would say just make sure you set that bar. I mean, for example, from my office, Wendy does not need one. Brooke does. I mean, she gets calls any time of the day or night from law enforcement or victims or whoever. Wendy's work is primarily when she's at the office, so I would just because we're in the nature where things can happen in the middle of the night, doesn't mean that Wendy has to be in on it.
Would it behoove us to put in there employees that are required to answer 24/7, 365?
I think it's better to keep it, we can add it, but I think it's better to keep it vague. Employees who are determined to need a cell phone for business purposes.
Okay.
It kind of, and then they have to go through their department head, when folks need it,
Right,
but he has said no, he's not gonna do this. That's his choice as a department head.
Right.
An elected official. Dana's folks are out of the office, which is also what it says here, someone who works out in the field, and they went to their department head and he said yes.
right.
So I
Which,
think
and
this
they
way
also
just
have
keeps
to
it
be-
vague.
Right, but also, you know, they are required to, if there's something big, they're required to answer a phone.
Yeah.
You
Yeah.
know, so, vague is good, but also not vague.
Do you wanna add it,
Well,
the language?
I mean, I think the language is good, but also, what I'm trying to say is, narrow the department head, say, oh, you know, you're a nice guy, I agree, you don't wanna pay for a personal cell phone, so I can justify.
That's where our management
Okay.
skills come in of
It-
saying, justify this to us.
Sure.
Easy for road crews because they're out of the office all
Right,
day.
yep.
I'm trying to think of someone else, but
Right,
yeah.
no,
But
no,
no,
I'm
if-
okay with that.
Read it over, and if you
Yep.
see something, let's add it by next Monday.
You got it.
Okay, and again, edits have never bothered me.
You're a good thing.
Is this for,
Yes.
perfect, thank you. And then the other thing is Franklin's phone bill. I think we have two different issues with that we have to discuss. One is those for fiscal year 16. If we want to start with the phone policy that doesn't say you have to turn in a bill showing your calls, then I would say, let's start next month when this is adopted and go ahead and pay from that point forward. If we are going to say that this is retroactive, back to the beginning of the year, then we pay those back to the beginning of the year. That's our job as, again, management. I think it's based on this because the practice and the precedent set, again, long before I was here, was commissioners disclose who they're calling, who they're talking to, because we're public servants. The question of last year, we need to discuss that, I think, after we decide this year. So,
And I think and correct me if I'm wrong, Ms. Ann, but I thought I made a motion to, this was 2 months ago maybe, to pay bills, phone bills, as long as he followed a certain criteria.
And I believe it was starting at that time, but I would have to go back and look
Okay.
at the minutes to
So we set precedents. I made a motion to pay if he followed. At that time, I came and talked to Commissioner, not Commissioner, to you, and I talked with Mako on that. I know we did do something in one of our meetings.
we did, I just have to figure out how many paper clips I have,
Sure.
attaching everything.
And that was from that point forward.
Right. We paid that bill, as I recall, and I should have highlighted what paragraph, so I'm sorry for the.
No, you're right.
How far back are the requests for reimbursement? That's the
I
question.
think it's 2.5 years, or 2 years, I forget what it is on there, I think it's 2.5 years. I was paid 4 times in those 2.5 years.
Okay, so here's what the minutes say. Commissioner Salifka moved to be reimbursed for his past 2 years' phone bills. Motion died for lack of a second. Gotta be more in here.
What's the date on that?
Not that,
What's the date on that?
I read it when I printed it, so it's gotta be in there somewhere, I think. I don't know the date of this one.
Commissioner Corthal's moved to pay the current bill and future bills that meet the current criteria. Maybe I should read the whole paragraph. In response to Commissioner Slivka's request for partial payment of his cell phone bill for the past 2 years, Commissioner Corthals has contacted the county attorney and accounting office and received a letter with requirements from the IRS. The county attorney suggested he would review Commissioner Slivka's itemized bill, redact personal calls before the bill is submitted. Commissioner Corthals moved to pay the current bill and future bills that meet the criteria. Motion seconded by Commissioner Slivka. Voting in favor, Slivka and Corthals. Voting no, Ober, who was against allowing the current bill. Motion carried.
What was the date on that?
That was May 16th.
So, like I said, if I could comment on this, number one,
Things in our-
I remember suggesting the redaction, I don't remember volunteering to do it. Secondly, when you are going to do a reimbursement and you're gonna do it according to a policy, you have to do it according to the policy that was in effect at the time that the expense was incurred. So if, whatever happened way back when all these reimbursement requests came in, when some were paid and some were not paid, the question is, what was the policy in effect at that time? Clearly, once the so from May on, there was kind of a more clear answer, and then if the county commissioners adopt this, there'll be a very clear answer from here on. The question is, what was the policy in effect at the time of the previous times when those expenses were incurred?
I think they just turned in their claim. That's what the judge had done all those years.
And so that's number one. That's the policy you need to hold to. But secondly, it doesn't really matter. By plenty of longstanding Montana law, if I, as a county attorney, get payment for use of my phone for county attorney business, that is now a public record. The only exceptions to that are my personal privacy interests, which would be a little more limited, and protection of confidential criminal justice information, which I just talked about. Anything else, it doesn't matter how far back we go, though it was all, that was the state of the law and it was the state of the Constitution when I became county attorney. So for Commissioner Slivka, when you became county commissioner, the law was already set, that if you got payment for a phone, that was a public phone. If you got payment for a car, that was a public car. If you got payment for a computer, that was a public computer. And as such, it's an open record to the public with exceptions. Exceptions are your personal privacy, which are limited. It's really wouldn't be even your protection. I mean, like your medical, something like that, absolutely, it's nobody's business. It'd be more of privacy of maybe family members or somebody else who just talked to you on that on your personal phone, which is not public. Or if, I don't know, if there was, and you probably wouldn't be dealing with any confidential criminal justice information, but if you were, then yeah, that would be limited. So that, regardless of the policy, that would be the state of the law. You got a, I don't know, February of 2015, they reimbursed you for a phone call, for use of phone that month, okay. That month, that's a public phone, which both is public and private, so your records will be open to review. But the way public records work under records requests in the state of Montana, you don't submit everything in advance. He doesn't turn in his call log every single month in order to get paid. I guess you could do that, but really what it is at any point, a member of the public can call up and go, hey, I want to go through your emails. All right, come on down. Go through them. But I'm not going to print out every email I did every week and give them to you proactively. You know what I mean? It's generally upon request you get to review, rather than I'm going to print pages and pages and pages and waste ink and paper for a request that may never come. Does that make
Okay.
sense?
It does, but it doesn't clear up the water, and this is the reason why.
Okay.
Since I took over in April, is that correct? Is that when?
I think so, end of April?
Seems like about 5
Forever years ago.
Right,
But
okay.
during this time, Commissioner Obert has asked for those records from Commissioner Slivka. Does that so even though, can she as a commissioner request that information? And I'm not here to take sides, I need clarification. Because if we're gonna make a decision on whether or not Franklin does, well, obviously he deserves money for using his phone, but are those things that because she did make a request, just like if he were to make a request from her to get certain information, does that solidify what you just said?
Yeah.
Okay.
But I honestly think that she can make that request even if you don't reimburse it. We had a case in Department of Justice when I was in the EG's office, and some people on the staff were using personal email, sending stuff that was official business. Well, guess what? They didn't get paid to reimburse for that personal email, and every bit of it came in. We went through hundreds of emails from people's personal accounts and turned it all over. If you're doing your job using personal email or personal phone, it's now public record. It's the people's business.
So,
Whether you get reimbursed or not.
okay.
But the point is, you also, the statute also requires costs of gathering that information. So if it costs you $25 to go print off all these things, then she's to pay $25. But she doesn't pay it to you, she pays it to the county. So then, now we're really messy. Because the county has
So-
to pay to produce that.
Let me ask a
Hopefully,
question.
that's why I said, hopefully we won't be in a
Sure.
merry-go-round of litigation over this amongst the three of us or four of us.
So let me ask a clarifying question. Do we know what the policy was before?
We do, it was not written down. I don't know if that makes a difference, but here's an email that we have, and the response was from Corey, and he said, for clarity's sake, share this. It's from the accounting office. As we move towards a new fiscal year and have several newly elected officials, I'd like to clarify how reimbursement is treated for claims submitted by elected officials. She mentions a number of things, including personal cell phone use. A few years ago, at the conclusion of one of the annual audits, the auditors gave us a finding citing that we didn't provide sufficient documentation on a majority of our claims that were reimbursed to elected officials. To correct that finding, it was decided that there had to be better documentation to support reimbursement. They felt we had insufficient internal controls, opening the door to misuse. Changes were made to the travel per diem policies, specifically on phones as well. I don't remember the exact audit year, but it's been a policy we've strived to follow since. Elected official claims are still looked at every audit season, and while some of the criteria on how much can be reimbursed may have changed, the documentation part has not. The commission at the time had said, the accounting department had gone to the commission and said, why don't we go ahead and just have the basic bill and not the calls included in these bills, to save paper, to save file space. The commission said no. We want commissioners' calls to be delineated so that a citizen can walk into your office and look at it right then and there. That has been the policy ever since, and that's what Elaine and I were striving to follow. And that's where the accounting office, knowing this history, because Debbie was here, she knows this history, and so she comes to me and says, I don't have a bill for this. I don't have any ability to reimburse this. What do I do? She's going back to this history, so she's following a practice and a precedent that we don't have a policy for.
Okay. So my next question is even though that's the past policy, does that violate state law?
Does that violate state law?
Yeah, that policy.
Saying that you need to turn in your bill?
Yeah,
No, it doesn't violate state law.
itemized bill
No.
before you get reimbursed.
Okay. If you want to set that as your policy, you can do that.
Okay.
There are some, well, here's where you're gonna get more costs. If you go back to a certain point in the past, your phone company is gonna say, if you wanna get, you need to pay us a fee for us to go back. Cause I've had to do that before. I've had to go back, sometimes for bank transactions or phone transactions, if you go back, let's say more than 9 months, you have to pay a fee for them to get that. So you may get some costs there if somebody wants to do that, but, no, I mean, if you say this is public phone and this is public, your public work, then yeah, you need to provide those, you can do that. I mean, most people don't do that for 2 reasons. One, if you request it for a public official, they have to produce it anyway. And number 2, most of the time, you're gonna be producing reams of paper that no one's ever going to look at. So that's, my view had been, you can do that, legally it's allowed. The more practical policy is, do it when it's requested. Everybody just needs to understand that if it's requested, you're gonna have to comply.
So,
The concern is, we've had 5 different topics in the last year where we have run into what our so-called policy was in the past. And it wasn't a policy. It was an understanding that some people had and others didn't. Or it was a custom that was followed most of the time, but not all the time. Or it was a handshake agreement that not everybody was in on. That's where you have murkiness, and that's where you have lawsuits. Lawsuits happen when there's a lack of clarity. And also, when there's a lack of clarity, then people don't know the expectations that are on them. So what I would say is, on all of these things, this is great that you're doing a written policy. Then now the clarity from whatever day you sign that going forward, that's gonna be the way it is, so.
So now to answer Franklin's concern, is he entitled for 2 years of reimbursement? Is he entitled to just the ones that he's complied with of the past practice? Or is he entitled for, since he took office, minus 4 times?
As a general rule, because number one, it's still not clear to me what the past practice was at the time when he was first submitting those claims. But if he submitted claims, and sometimes they were paid and sometimes they were not, but the times when they were paid, he had not provided his bill, then yeah, you need to pay him for all of those.
Okay.
If those 4 times when he was reimbursed, it was when he provided the detailed call log, then that looks more like you're following a consistent policy.
Okay.
But if he incurred that expense on the understanding that he's doing county business on his personal phone as a county commissioner, and therefore he submitted those, then you're gonna have a hard time denying those unless you specifically said, we'll pay him when you provide the call log. He provided the call log 4 times and those 4 were paid. He didn't provide it the other 12 times and the other 12 weren't paid. You have to have some consistency.
So do we know why those 4 times were paid?
You know, they're turning the same thing from day one.
I don't know,
Because-
before my time is
Because Annie Lane was sitting right here, and I was going through the claims, and Gary, this is about the second or third time I saw that. And I said, I think that's a good idea. I says, carrying 2 phones, and Elaine agreed. And all he had on there was personal phone use, $20.
Who's that, the judge?
Yeah.
Okay. Now, it's a little stickier for the judge, because the judge, for example, they call him, and I know this has happened many times with both judges, they call him at 11 o'clock on a Friday night for a search warrant, okay? Now, that becomes a record in that case. They have to do a recording, they have to do a transcript, they submitted all that stuff, right? But it could be a search warrant that is, we don't actually file the case for 30 days. Up until it's filed, that's confidential, okay? That particular, until you actually do the return on a subpoena or a search warrant, it's confidential, okay? So, or at least till you notify the person that's been served. So, there may be some odd exceptions to a judge, but as a general rule, it's still.
And the road crew, like I say, every 6 months, they just turn in a bill. 6 months, I think it's $120 or whatever it is, that's all that's on the claim. That's all Flyner was doing. He just turned in these claims and,
So I guess before we could,
Well, is it?
Before we go
Commissioner
forward.
Wilbur, is that your understanding with the road crew and Mr. Kleiner and the
They're
judge?
employees.
And the judge?
They're employees. The judge's situation was different. You just described it, and Commissioner Slivka's commissioner. The situations are totally different, and that's why it's good that we finally have a policy. But my understanding was that the practice and policy, back then, was only the judge getting reimbursed, but the commissioners had said, commissioners will show their bills so that the public can come and take a look at any time. My understanding of the policy was for county commissioners to be reimbursed, they had to provide the same information that precedent had the other commissioners providing.
Okay, so
So-
when was that communicated to Commissioner Slivka? Because if this is not a written policy, we're just going off of, like I said, handshakes, we're not really in on it, or understanding that half are understanding it and half are not. That's the problem.
It was communicated to Commissioner Slivka by the accounting office on various times, I cannot give you the dates, and by Elaine and I when we were together in commission meetings. Now, I don't know what happened with Elaine and Franklin alone, but when it was the 3 of us and this was brought up in public meetings, it was communicated at those times. So I would say it was almost monthly since he started requesting the reimbursements.
The
And
first-
oftentimes it was written on the bottom of the claims as well, so it was in writing.
So do you know why he was reimbursed 4 times then?
I do not, I would like to see who approved those, what the situation was, but I know off the top of my head, I certainly cannot.
you're the one that signed the check.
Franklin, you know as well as I do that the commissioner doesn't come in and sign each check every week for the claims. It's done from our stamp, it's electronic. So, you know
I
that.
guess this is my, so if it opens the door to litigation, if I'm following you correctly, that if he was paid really 3 times, because the 4th time was done by public meeting, correct?
Yeah.
In May?
Yes.
Okay, so really 3 times previously, if they paid them and there was not that, the policy that Chairman Olbert just read, and I know you're not a man, but what do you call a lady chairman?
Chairman.
Okay.
I'm fine with
Okay, okay.
Yeah.
Let's
That's,
not get into
Presiding officer.
there you go. Then that opens us up to litigation if they just paid those 3 and not paying the rest. Cause then it looks like we pick and it was picked and choosed. Or it solidifies not paying him because those 3 times he turned in a bill. So we have to get to the bottom of that
Yeah,
before.
the bill is exact every time. Well, the first couple times, she says, well, you gotta have, there's 4 pages. Well, I looked over there was 4 pages of Verizon, 1 on each side. So that's what I did. I turned in everything that comes from Verizon, that's what I turned in.
So I guess we need to go back to those 3 times, look at our bill, or our claims, thank you, our claims, verify that. I guess where I stand, if coming by from what you said, if he turned in more information those 3 times, then we're sticking to this policy from the past. If it wasn't, then I think we're opening ourselves up to problems. So I think that's our beginning point, is finding out why he was paid those 3 times and the rest not. Does
I
that?
think it would be a wise thing to do exactly that, to have the answers before making a decision. We can
So-
certainly-
I guess I'll do that. I'll go down to Debbie and find out when it was paid, and why it was paid, or whatever. I'll look at the claims.
See what the black and white
Yeah.
says.
Um,
One question I have as you do that, and I think the mileage is different than the phone, and I don't think we're gonna have time to get to the mileage today, because we have Board of Health at 3, and we have somebody coming in for training, so we can't skip it. Last fiscal years, we have a policy, and every year we get an email from the accounting office that says, get us your bills for last fiscal year by this date in July, because we close out the previous fiscal year. Now, you've been advocating for Franklin for the phone bills, but your predecessor did not. So that fiscal year closed without those bills being paid by following the practice and the precedent set at the time. Last year, we closed out the fiscal year again with the understanding we were following precedent and the practice at the time. This year, I can see going back if we have to, depending on what Nick finds. But I'm not sure how we open a past year, because this should have been taken care of in those fiscal years, either with you or the previous county attorney. And the other question of where does it come from in the budget? So I guess those are 2 of my questions is, do we have to go back, and how far do we go back? And if we do we do it for everybody? Carla, again, your predecessor, before she left, had paid for a conference and airfare and didn't turn it in till that fiscal year had closed. She was told, no, you're not getting a reimbursement for this because we're now in the new fiscal year. Do we then pay her a check also, and anyone else? What kind of can of worms are we opening?
I guess
So-
what would help answer that is what is defined through MCA. What's payable and what's not.
Are you talking just about the phones at this point?
No.
Well, I think we have to, I'm gonna talk about the other also, because it's the same question, but we only have 13 minutes.
Yeah.
So right now, yeah, I am just talking about the phones.
Well, the phones is a quick answer. Number one, if he
Oh,
What-
yeah.
he's-
Then I misunderstood you, I apologize.
No, no,
turned
that's fine.
in, what I understood is that he had turned in claims prior to the close of the fiscal year. Or that he had on multiple occasions not turned it in because he said they've already denied him. They've continued to deny him, so there's no point turning him in. That was my understanding from Commissioner Slocum telling me that. So I have a hard time with this, well, he didn't turn this stuff in time, therefore we're not gonna pay it, when really what it was a pretty regular policy of denial.
Based on
The date is on all the claims,
and,
when it was turned in.
precedent.
So I
But I
guess,
hear what you're saying. I just wanna make sure.
I
that
guess
it's
if it
out
were
there.
for me, I would not feel comfortable paying claims that never were made up in a claim. If it's something important to me, regardless if I get denied all the time, I'm still gonna turn in a claim.
Well, I have.
Okay.
I have, the
Okay,
claims
well,
are in.
they were all turned
And I went through Debbie's, she brought everything out, everything where I'd been paid, see. And that's where I found that one that was even older, I didn't even realize that, and then looked back and I can't remember, that one was
Yeah,
very.
and I mean, if there's claims, I'm okay with that, but if we're paying a month just because he was commissioner during that time, but there was no claim, I have a hard time with that.
No, there's a claim, everything that I put in there, there's claims, it's all right there.
Okay.
Okay, mileage is easy. Statute authorized commissioner's mileage, that's it.
The mileage isn't easy, and we need to talk about that, because statute says if you don't have the money in the fund, you pay it out of your own pocket. For your budget.
Where does the statute say that?
42005.
It says county commissioners are entitled to mileage, and if the county doesn't have the mileage, the county commissioner pays it out of their own pocket. Is that
No,
what you're
that's
saying
not,
it says?
no, but we can, again, we've got Board of Health, we've got a quorum sitting right here, and we've got a guy
Yeah,
coming
'cause
from Helen
one
to
might
do
be
the
gone.
training. So I would like to request to table this till next week, but it is more complicated than that. And you and I kind of talked about this in a meeting. With your budget, if you have travel, for example, if you overspend travel and it goes into the negative, you work with Debbie for a budget amendment and you take money from another object code like contracted services. Then you have enough to pay your travel. For the three of us, we need to work on that. If we get to the end of the year and our travel is at negative $250 and a claim comes in for travel, it is that commissioner's responsibility to work with the rest of the commission and with Debbie for a budget amendment to put more money into that account from, again, utilities or some other object code within the fund. If they choose not to do that, yes, there is statute, and I sent it to you in an email, and it says, anyone who overspends their budget is responsible personally for that over expenditure. So, yeah,
Okay.
it's more complicated than just willy-nilly. There's a responsibility. And if we get to the end of the year and he hasn't said, hey, I'm gonna be bringing you a claim for $2,000, we need to put more money in travel so that can be paid.
When I
We don't
talked
know
to
that
Debbie,
that's
she had
coming, and then we
all this
close
other,
out the
she,
year, and here we are in
she
the
listed all
new
this,
fiscal
and she said, we just,
year.
at the end of the
I
year.
can
we
give you
figure what
examples,
we
we just don't have time. So
My-
I'd like to have this as
I
a
would like
serious
to just
discussion.
finish with this point, though. My understanding is that you felt, just as a personal matter, that commissioners should not be reimbursed for mileage, and that you actually said that to Commissioner Slivka. Which, that's great that that's your personal view, or that that should be a
That is only my personal
sacrifice.
view. I do not get to make decisions in this chair on my personal view, though I never have. That decision is only based on if, and again, I've got the examples to share with you. If a part is not documented, if there's no receipt, if there's no money in the fund and he hasn't come up with a plan, those are all legal reasons for saying,
Every plan
we're
I got
not
in there,
paying
they just-
this.
I bring them in
But
short.
I have said in a public
They just-
meeting, I don't believe in this, but I'm voting for it because it's legal. So, you know, yeah, you're absolutely right. I don't believe in that, especially for in-town travel.
I never charge to a
But-
regular meeting. He's written me
but-
like today, I never charge on it. The only time if I come in
But the
tonight for
rest-
another meeting, I charge. When I go to wherever
Okay.
conference calls, I do.
The rest of what you said is false, and I would like a chance to defend myself on that, but I can't do it in 8 minutes when we have a Board of Health meeting. That's not fair to the rest of the Board of Health, it's not fair to Jim Murphy. So I would like to table that until next week so that we can look at things in full, so that you have a full picture of what's going on right now, because you have one side of a multifaceted story, and you need all the sides, and so does Nick.
That's fine, and
And
we've
so does
talked,
the public.
we've talked about this a little bit,
Mhm.
I know, and you have told me that, hey, the money's not there. It is still an obligation of the county commissioners to meet that statute. If you have to move your funds, then you do it.
That's exactly what Debbie
But
told
if
me.
you don't know that bill's coming through and the commissioner who doesn't come forth and communicate that, how do you know to move the funds?
All right, I'm,
That's the issue. It's the three of us that have to work together.
okay.
That's so
I
damn
will just-
tired of your
I will
lies
just-
all
I'll
the
just tell you,
time.
Commissioner, I'll just tell you, the reason I'm pushing this so hard is because this is a very, very easy thing to fix. And yet, it is among the top 2 or 3 lawsuits potentially facing this county. Commissioner Slivka, I have 4 times in private told him, don't sue the county. I'm gonna come to the commissioners and ask them to to reimburse you. These are legally obligable reimbursements that the commission should do. I don't care if you don't get along with each other. I don't care if there was some past vague policy out there. This is a lawsuit that's waiting to happen, and guess what? The county's gonna lose this lawsuit, Commissioner Ober. That's why I'm pushing this.
I
There's
have no
reason.
problem moving forward correctly. Just work with us on it. But
I
don't
have
accuse
asked-
me of things that I haven't done.
I have
That's not
asked,
fair and that's not right.
Commissioner Ober, I have asked you repeatedly in private on this. And I have
You've asked me
asked,
once.
I've asked Debbie repeatedly, what's the status of these claims? Something is holding up these claims. Debbie has not produced them for me. Debbie has not brought them to the county commissioners. Whatever it is that's holding up these claims needs to stop right now. This needs to come to the commission and it needs to be paid.
So,
And if it doesn't, we're going to a court, we're getting more bad headlines, we're losing a lawsuit, we're paying attorney fees. Absolutely unnecessary. That's why I'm being such a stickler on this.
so Monday, when we meet again at 1:30, we can have all this information, so we can start from right here and get this handled next Monday. Whether this is the only thing we talk about, I think this is what needs to happen.
Yes.
Because I'm sure I can get my cell phone thing done within a day. So everyone's heated, so, and we do have a prior engagement. So next Monday at 1:30, this should be the only thing on our docket to handle this issue.
No, I have two more that I'm bringing next Monday, but
Okay.
we'll deal with this. We should be able to deal with this. This is an ounce of prevention that's better than a pound of cure.
Oh, yeah.
And I understand, I apologize for being heated over it, but I'm telling you,
Oh, no,
there's no reason to even have this as a lingering issue. It should have been disposed of long ago.
I think I agree. I think
I
we
do
need
too.
to just hammer this out and start at 1:30 and be done with it.
There's
Are
a
we
question
good?
on the
Bill.
floor.
One quick question.
Yes,
Now, this
Susan.
new policy, is it gonna make
Thanks,
the
Will.
auditor happy?
Yeah, yes, it will, because it clarifies for everyone, all employees and elected officials, what's required.
But
So
they're
yes.
requiring you to turn the bill in
What's that?
to make the auditor happy.
What's that?
Aren't they requiring you to turn the bill in to make the auditor happy?
Yes, yes, the auditors require that we turn in a receipt for any reimbursement, especially to elected officials. That will solidify that requirement, so,
What is making happy, they
There
want
should be any more litigation.
Receipts.
Well, they want more than receipt, they want what they're paying
No, only at the request
for, somebody.
of
And that's
of
not-
the public.
that's not per the auditor.
No,
That's
that's-
per county policy.
Yes.
Okay.
The auditors don't care about that, they want the receipt. And that's what's been lacking sometimes too.
Okay, I was just mixing them.
Right.
Yeah.
Yes. So to clarify, the itemized list is at the request of the public. This policy and the receipt of what is paid is required by the audit. So there's two different issues there.
All right, so it is 2:55, this meeting is adjourned. Thanks, Ann.
Are we meeting up here?
Yeah, we can do that. Yeah, I'll run downstairs and see if we have any folks down there. Thanks for coming, you guys. Nice to see you again.
Yeah, how are you guys doing?